Hello, thank you for joining us today. Today we will be speaking on currency control regulations in Russia. And while we are waiting for everyone to join and check the technical issues, let me just briefly tell you that we'll try to put out everything we are planning to tell within 1 hour. Hopefully, there will be room for questions. Don't hesitate to use the chat function or send us email if it will not be convenient to do it right now. We'll be pleased to answer everyone. And today we will be telling you about the currency control regulations. It will be myself, Ilya Aleschev, my colleagues Tatiana Astahova and Vlada Kovaleva. And once again, thank you for joining us. So, uh, this is quite a dynamic topic which changes rapidly. It's one of the reasons we want to keep you updated on the recent developments. You may have seen the news on quite a turmoil recently about the deposits being repaid to Type C accounts. That situation has developed and resolved itself within, I believe, a time span of 1 week, which is an illustration of how fast things could be changed in a Russian regulation landscape. This is indeed quite a very fast-paced area of regulation. Not every change, which is, frankly speaking, quite important, makes its way to the news headlines because the deposits was a sensitive issue which affected quite a lot of clients, and therefore the media was apt to catch on. But other changes could be more subtle on the face of it, and the media maybe not reporting them, but they nonetheless important. So will be something we will tell you today will be the issues you may have heard of earlier. But nonetheless, they are the groundwork, and the amendments will be highlighted that slight changes could be a difference in the decision making. So we hope that today we'll be updating your knowledge on this dynamic topic, and that information would be useful for decision making. So I'll let Vlada tell us the first part of our webinar about the key regulatory framework. Thank you.
Hello, everyone. Today we'll walk you through the current state of Russian currency control regulation and what changed recently for foreign capital in Russia. So we'll start with a quick overview of regulatory framework to understand where these rules actually come from. Then we'll go through key definitions you need to have in mind because a lot turns on how a person or entity is classified. After that, we'll look at the core restrictions currently in place, followed by recent developments. We will also touch on recent judicial trends since the courts have started shaping these rules and how they are applied in practice. And finally, we'll close with some available solutions that we've seen work in the current environment. So let's start with where this regulatory framework actually comes from, because it's not just one law, it's actually a layered system. The foundation is federal law on currency regulation and currency control. That's the base statute. But since 2022, the real action has been happening through presidential decrees. A whole series of them have introduced restrictions that go well beyond what the original law contemplated. On top of that, we have guidance issued by the government implementing rules that flesh out how these decrees are supposed to work in practice. Then there is court cases layer, which matters more and more as disputes make their way through the system. And finally, implementation practice, essentially how banks, regulators, or government commission actually apply all of this on ground, which can differ quite a bit. So when we talk about currency control regulation in Russia today, we're really talking about all of these layers. So statute, decree, guidance, court decisions, and practice. And you need to look on all of these layers to understand where things actually stand. So let's move on to definitions. We want to spend real time here because almost everything downstream depends on correctly classifying an individual or entity. First, there is a basic distinction between tax resident and a resident as defined in currency control law. They are not the same thing, and people often conflate them. So under currency control law, a currency resident includes citizens of the Russian Federation, foreign national holding Russian residence permit, and Russian legal entities, with exception of residents of special administrative regions and foreign branches and permanent representative offices of Russian legal entities. Tax residency actually works differently. It's based on physical presence. Individuals who have spent at least 183 days in Russia within a calendar year are considered tax residents. Notably, short stays abroad of up to 6 months for medical treatment or education don't break this period. And on the corporate side, tax residency captures both Russian legal entities and foreign legal entities that are actually managed from Russia. Now, there is a third category worth flagging. Residents who are exempt from certain duties. This mainly covers an individual who is currency residents and live outside Russia for more than 183 days a year. Such persons, despite technically being currency residents, is revealed from some of the reporting standards or repatriation obligations. And this distinction matters a lot for Russians living abroad. Once we've passed residency, the next critical classification is where a non-resident counts as friendly or unfriendly. And this single label drives almost every restrictions that we'll discuss later in this presentation today. A friendly non-resident is a citizen of a friendly state and an organization registered in friendly state that conducts its main activities or earns most of its profits there, or a disclosed controlled foreign company, or an individual controlled by companies or citizens from friendly states, but only if that control was established before March 1st of 2022. And this date is actually matters because the control set up afterward doesn't get the friendly treatment. An unfriendly non-resident is a foreign citizen holding citizenship or residence permit of an unfriendly state, or an organization or entity that registered in an unfriendly state and conducting its main activities or earning most of its profits there, or an individual controlled by unfriendly non-resident. And here it doesn't matter where that individual is actually registered or based. The controlling relationship is what actually matters. So the practical takeaway is don't just look at nationality or a place of registration in isolation. You need to trace control relationships and timing to properly classify a counterparty. So this slide is basically a cheat sheet for classifying individuals because in practice you often see people holding multiple citizenship or residence permits, and the combination of this determines the outcome. A Russian resident is someone holding a Russian passport, full stop, regardless of what other citizenship or residence permits this person may have. The same logic applies to someone holding a Russian residence permit. That alone makes them a Russian resident, even if they also carry other citizenships or residence permits. A friendly non-resident is someone with citizenship of a friendly state, who may additionally hold citizenship or residence permit of another friendly state. But such person doesn't hold a Russian passport or Russian residence permit and has not any unfriendly state citizenship or resident permit either. And an unfriendly non-resident is someone holding a passport or even just a residence permit of an unfriendly state. And it's the key asymmetry here, because unlike friendly category, this classification sticks regardless of what other passports or residence permits this person also holds. So a single unfriendly state connection is enough to pull someone into unfriendly bucket, even if they also hold friendly citizenship or residence permits. So this asymmetry is very important and most easily missed features of this framework, but it's very important to notice such thing. So now let's move on to see how these classifications actually play out in the restrictions.
Now let's briefly go through the key restrictions just to make sure that we are on the same page. The first one concerns transfers from Russian bank accounts to foreign accounts. As a general rule, residents from unfriendly jurisdictions cannot transfer funds abroad from Russian bank to a foreign bank, except for an amount equivalent to their salary earned in Russia. This restriction does not apply to the resident from friendly jurisdiction. And the next restriction concerns debt repayments. Russian residents can repay debt to non-residents from unfriendly jurisdictions without government commission approval or without using a Type C account, as long as the total payments to non-residents from unfriendly jurisdictions do not exceed 10 million rubles per month. The same rule applies to a friendly non-resident who acquired the relevant claim after the 1st March of 2022. The next restriction concerns the transactions involving Russian securities and Russian real estate. If a non-resident from an unfriendly jurisdiction transfers Russian securities or a real estate located in Russia to a Russian resident, government commission approval or the use of a Type C account is generally required. There is an exception for friendly non-resident who did not acquire the securities or the real estate located in Russia from an unfriendly person after 22nd February of 2022. So the ownership history of the securities and real estate can also be important. The next restriction concerns shares in Russian companies. Direct or indirect transfer of Russian shares involving person connected with unfriendly jurisdictions generally require prior government commission approval. This covers transactions with Russian residents between persons connected with unfriendly jurisdiction and also certain transactions involving third country persons. For transactions exceeding 5 billion rubles, also a presidential approval is additionally required. So the status of all parties and the structure of the transaction need to be carefully reviewed before the transaction is made. As for loans, Russian currency residents may grant loans only to non-residents from friendly jurisdiction and only in Russian rubles. The same 10 million ruble monthly limit is applicable to dividends paid to unfriendly non-resident. The total monthly amount that exceeds 10 million ruble should be made with government commission approval or with the use of a Type C account. In practice, however, obtaining such approval can be difficult and time-consuming. Therefore, Russian companies often choose to pay dividends to a Type C account instead. The practical problem is the funds credited to a Type C account are very difficult to access, and there is only a limited list of permitted withdrawals. There is also a corporate governance issue. If unfriendly shareholders hold only a minority stake, they may have very limited ability to influence the company and in practice to require it to seek the government commission. As of the 1st June of 2026, amendments to the presidential decree number 95 were introduced by the new presidential decree. And this new presidential decree extended the special payment procedure to the bank deposits held by the persons from unfriendly jurisdictions. In practice, banks initially applied the 10 million ruble limit at the bank level. As a result, the funds released from the deposits were generally transferred to the Type C accounts, regardless of the size of the withdrawal deposit. This was clarified by the central bank. The central bank confirmed that the 10 million ruble limit was applicable to each individual depositor. Therefore, the deposits of up to 10 million rubles could have been paid to the depositor's regular account. However, this clarification did not result in the release of the funds that had already been transferred to the Type C accounts. In practice, banks did not unblock these funds. The situation changed only with the presidential decree number 5500. The following its adoption, banks began releasing the funds of unfriendly non-resident that had been transferred to the Type C accounts following the closure of the deposits. So the July clarification changed the interpretation of the 10 million ruble limit, while the August decree finally addressed the practical issue of funds that had already been placed on a Type C account. And finally, a recent development concerning contribution to the charter capital of foreign companies. As a general rule, such contribution require government commission approval. However, there is an exception for contribution that are made starting from the 1st April of 2024 and onwards, provided that the aggregate amount does not exceed the applicable threshold. Importantly, as of 1st June of 2026, the threshold was increased from 15 million rubles to 30 million rubles. As of today, a contribution up to 30 million rubles can be generally made without government commission approval. And now I would like to hand over to my colleague and the partner of AT Lawyers, Ilya Aleschev, who will take you through the next part of the presentation.
Thank you. Next slide, please. Another further quite notable development is that the Supreme Court of Russia has issued guidelines on resolution of disputes related to currency control regulation. As you may heard, they is saying that the strictness of Russian law is negated by that they're easily sidestepped. This proverbial saying is quite a symbol of what happened in the ground of currency control regulations after they have been started to be amended in 2022 with the strict barriers on transfer of capital being reassessed by a legal community on how they could be circumvented or sidestepped, and that gave quite an incentive for a lot of I would say, if not schemes, but say creative solutions to sidestep these regulations. And the courts have started to address these schemes quite promptly on case-by-case basis. One of the notable cases you might heard of was IKEA case, when the sale proceeds of IKEA goods stock left behind when IKEA exited Russian market was sold. And prima facie, the money had to be paid to the Type C account, which would have locked them in Russia without any use for the IKEA business. So they have decided to pay to the order of the foreign company to another person, another entity, which was a friendly company, was a Russian company. And the court invalidated this transaction and seized everything to the state, saying that the circumvention of the law made this transaction invalid based on the rarely applied ground of immorality and being contrary to good mores, which one kind of a public order ground of invalidity. And that rarely applied provision called for seizure for the benefit of the state. And that practice, starting from IKEA case, that started to develop during the recent years, and more and more cases were when the state attorney service, the prosecution service of the Russian state, acting on behalf of the state, started to seize businesses based on this ground, saying that the circumvention of currency control regulation, in particular sale of business regulation, sale without government commission, or restructuring, which was disguised as a way to circumvent the government commission consent requirement, That was the ground for invalidation under this immorality clause section of Russian Civil Code. And there was quite a lot of cases like that. Not every business which was seized during recent years was seized on that ground. A lot businesses were seized based on anti-corruption law, and some were seized under the extremist law, which were not covered here. But the immorality clause was quite a popular one as well. And what is quite interesting is that we see a sort of loosen it up a little in this guidance in Supreme Court, which saying that if the currency control regulation are being sidestepped, the appropriate ground for invalidation was another one, which called only for restitution. So the business should be left in the hands of the seller and the proceeds should be given to the buyer. And not seized to the Russian state. It's yet to be seen whether this relaxation is on paper only or it would be actually applied, because we haven't seen cases yet after this guidance was issued. It was quite a recent one, so it's obvious that the cases are not yet been generated by the court system. But it's quite a curious development. We don't see a lot relaxation of rules. We rather see more tightening of rules during the recent years. So that's quite a curious development, one we have to keep an eye on. But I would probably not be advising clients to be relaxed and thinking that if they would sidestep the government consent requirement, the worst thing could happen would be the transaction being reversed. It's still not impossible for the lower courts to apply the immorality clause. It's still there in the civil court. So I would say that's be reasonably optimistic, but not to be carried too far by this guidance. Other interesting guidance in the Supreme Court review was that artificial structuring of transactions to fit it under thresholds would be circumvention, there would be ground for invalidation. So that was quite obvious earlier. That was something lawyers typically advise the clients again, but still it's provides more clarity and more predictability to see that we have these now confirmed by the Supreme Court, and that it is not something you should do, splitting out the payment to fit these 10 million rubles, for example, threshold Tatiana mentioned earlier. And another popular, I would not say solution, I would rather say a way to attempt to circumvent would be to stage an artificial moot litigation proceedings and seek for a settlement. That was based on the premise that courts' orders are not transactions, and the government commission consent is required for transactions. This is not required for example, settlement agreements approved by a court order. Well, now the Supreme Court has addressed this, well, I wouldn't say loophole, but a notion of sidestepping the regulation, that now the courts are advised not to approve such a settlement agreement. They should not be approved by court orders, and it's little doubt that the courts will follow these guidelines. So quite a lot of other guidance is provided in this review. We would not bother you with restating them in verbatim, but the general notion is that, save for this immorality ground of invalidation, all other guidance provided in this review are for tightening the rules. They are closing the loopholes and addressing quite obvious point of view that if the spirit of the restriction calls for certain transaction not to be allowed, just technicalities should not be a way to overcome the restriction. So quite reasonable, quite expected, now confirmed on Supreme Court basis. We don't expect Russian court would revolt against Russian Supreme Court. So that is something to keep in mind when say a creative counterparty and the Russian lawyers would be tempting you with some kind of creative solution to negate the restrictions. Next slide, please. So, you have heard a lot government commission consent during our webinar. So let's talk a little bit how this works in practice. Is it really a black box, or are there any procedures which could be at least used to predict the timing and the outcome of the whole exercise? So, uh, from the formally legal perspective, this is indeed a black box. The rules are quite short and regulations are quite short and leave a lot for discretion of the Commission. To start from, the Commission is not a state body itself. It is rather an ad hoc body which was created on the basis of the ministries. And on the ground, on the brick and mortar level, the ministries are the key part of the Commission. You don't deal with the commission as a body because they don't have an office, they don't have any employees. This is not something which is distinctive in a Russian system of government bodies. This is just rather an ad hoc, I would say, legal fiction concept which unites certain function of ministries. On the ground, you deal with the ministries, and the finding the right ministry is the first exercise, because we have this term, the relevant ministry, the ministry which is responsible for the industry the business operates in. So, for example, if this sale of consumer goods, that would be typically a ministry of industry. If there would be, for example, one of our clients is an architect bureau, their ministry is the Ministry of Construction, and so and so the agricultural business or owner of land which is used for agriculture would be the Ministry of Agriculture, and so on. So that ministry is responsible for the most of the groundwork related to processing the application, and the ministry's approach is quite different. The Ministry of Industry, for example, has taken the majority of application. They have developed the internal procedures, and they have designated staff. Ministries, other than the Ministry of Industry, they have quite various approaches. Some of them don't have much resources designated to this government commission application, and they are not that efficient. There could be quite a variety in approaches. Well, formally speaking, the application could be also filed to the Ministry of Finance, but it's not advisable to do so. And when the client's doing this, we have quite an interesting results. The reason is that the internal pipeline for processing the application is that the relevant ministry should collect a number of internal documents, such as responses and comments from other state bodies, not only ministry, but also, for example, antitrust agency. And these internal documents should not and could not be prepared by the applicant. They should be prepared by the relevant ministry. And the Ministry of Finance sees themselves as the final stop of the process where the commission is convened and the decision is made. They are not collecting this bundle of internal responses. They are kind of seeing this a bit of below them. And if you file to the Ministry of Finance directly, which is allowed by the regulations, but in practice, it would be either them sending it back, or I say rather sending it down to the relevant ministry for the groundwork, or responding with some kind of formal response, which is not resolving the application on the merits, but is rather something they are obliged to respond to any application they receive. So the practical outcome would not be achieved. So the suggested way is to file with the relevant ministry and then try to get the feedback from them on the progress. The feedback situation is also very different. Sometimes you just cannot receive any information. Just sometimes it could be a true black box when the phone number you are given when you file is just being dead, not responsive. Sometimes you are able to obtain some morsels of information on the progress. The deadline is not set in the regulation, the deadline for response. So the formally, the statute we had quite since 1990s sometimes something similar to Freedom of Information Act in other jurisdictions, which contains an obligation of state bodies to respond within 1 month to any written application or request sent by an individual or a company. So every Russian state body is under an obligation to respond something within 1 month. That is negated by responding with a response which doesn't contain any sensible information. The Russian state bodies are quite good at that. They would recite some statutory provisions and sum up with a paragraph which nicely written but contains no sense. That's the standard practice when they don't want to respond to you, but they want to comply with that obligation. So you would typically get the deadline for response within this 1 month because they wouldn't say we are violating the statute. They would say, oh, you have filed on that date. Within 1 month, you will have the response. But don't expect this to be a realistic deadline because the relevant ministry needs to collect information from other state bodies. They need to prepare the bundle. They need to send it to Ministry of Finance, and that Ministry of Finance will need to schedule the applications to the next committee session. And that is taken with certain pace, if I'm not mistaken, a couple of times per month, 2 times per month, depending on the season, whether the business activity is high or low. And that schedule, the amount of application they hear per session, is also depending on the workload, on the importance of other application taken from the view of the commission. Say if we represent a client who has a relatively modest business scale of operation, and at the same time, the major business is exiting Russia, and their application, of course, would be given a priority from the scale of economical impact for the country. The priority will be chosen, of course, internally by the commission, not by us. So the deadline given at the filing stage will be just a formal 1 month deadline, which is not reflecting the reality. One has to be prepared to keep that in mind. And while the bundle of documents supplied by the applicant is not that complex or vast, it still pays off to check carefully if everything is provided for. The corporate documents of the foreign companies duly translated to Russian, the names translated to Russian uniformly, because sometimes the non-Russian names of companies, key officers could be translated in a different way. They should be translated in the same manner they already been translated, for example, in the company register. The documents should be full, not just extracts from representing certain parts of the document. They should be complying with the guidance issued by the Commission. And of course, the bottom line is that Commission still has full discretion. It will make no sense hoping to challenge the Commission consent or refusal to give consent in litigation proceedings, just because there is, formally speaking, no grounds to do so. And of course, due to the policy reasons, I wouldn't expect personally that any Russian court would overturn Commission decision. And of course, there were no such cases yet. So filing for consent with Commission is something which is placing this case to the discretion of the Commission. Next slide, please. The guidance issued by Commission itself provides for the criteria they expect to see. This is kind of a guidance. This is not as any kind of statutory provision or statutory instrument, but that is an insight of what they expect to see. I would have to say that the guidance was prepared, obviously keeping in mind the sale of business and typically sale of major business, which was having an importance for the economy as a whole. So most of the cases Tatiana and Vlada described before, they don't look like sale of business. They are more like approving of certain financial transaction, a repayment of the law, for example. You may think that these criteria are not applicable to situation when you need government consent, government commission consent, not related to sale of business, and you would be right, but there are no other guidance available. So when we are preparing an application for some other kind of transaction which requires commission consent, but it is not a sale of business. For example, until the end of last year, the liquidation of a company which doesn't, which has unfriendly shareholder, was allowed to proceed without need for commission consent. Then the Ministry of Finance issued informal guidance which say that there is a transaction which leads to cessation of shareholding in a Russian company because, well, indeed, when the company is being liquidated, the shareholder ceases to hold the shareholding. That's something which hard to argue against. And from then on and currently, the liquidation requires consent of government commission. You may see that the criteria provided here on this slide are barely applicable to liquidation because there is no price being paid. There is not something you may give a discount from. Quite often, the value of the company shares in prior liquidation stage are zero, and there's nothing could be done about the continuity of the business, which is also one of the criteria the Commission expects from the sale of business. It is not expected to be continued. It is the whole idea behind liquidation is that the company should be liquidated. So these are just guidance, and sometimes you have to admit that it's not applicable to your particular case at all. It just needs to be kept in mind that if there is a sale of business and something is applicable, you have to consider where it's possible to adhere to this guidance. Next slide, please. Now, turning to case studies, let me discuss several cases when we had these Russian currency control and non-friendly restrictions applied to particular cases of the clients and how we could have alleviate certain issues caused by them. So in this particular case, we have quite a popular legacy structure, which was, you may remember, promoted by a quite reputable representative Russian legal community and international legal community for Russian clients for about a decade and a half ago. And the Cyprus holding is a sort of staple of company structuring in for Russian clients. And this particular legacy structure has survived until now. But the Russian client who is the beneficiary of the structure moved outside of Russia for some years ago. And this person was quite secretive, as many Russian clients do, and was quite reluctant against disclosing the Cyprus company as his CFC in Russia. So it was never disclosed. And he's living outside of Russia now, and he's not a Russian tax resident. The only Russian tax residents are deemed to be controlling person of a CFC. So even if he wanted to, he is not in position to disclose the Cyprus company as a CFC now. So now that we have the new restrictions related to unfriendly companies and persons, how this structure is affected by them. We have the unfriendly person Cyprus company. We could have potentially relied on CFC disclosure exemption, but this is not a disclosed CFC. It could not be disclosed now. So we have now this unfriendly structure, which affects how dividends, for example, from Russian LLC could be paid. And say if any shares in the Russian companies are to be sold, or the real estate, the actual asset the structure holds, would be sold, be something which requires government commission consent and a PAC exercise, not something clients are keen to do. So what could be the solution? say a direct approach would be advising the client to move in back to Russia, live for 1 year to acquire the status of tax resident, and then file the CFC notification with Russian tax authority. A solution one may expect would be taken by the client without much of enthusiasm, and that would be quite understandable. What are the other options? Say the Cyprus company is the only unfriendly connection here. The Cyprus company could be redomiciled to another jurisdiction, for example, to United Arab Emirates. So the redomiciliation between these two countries is possible. The change of jurisdiction takes some time. You have to comply with certain formalities both in Cyprus and UAE, but that could be possible, and that company would be now non-resident but friendly. Furthermore, if the client so desires, it could be converted to a foundation. The certain Emirates and free zones within UAE allow conversion of a company, including redomiciled company, into a private foundation. Private foundation doesn't have any shareholders anymore. That could be useful, for example, if the UBO would be considering either leaving Russian citizenship, for example, revocation of his Russian citizenship. This is a procedure some clients consider when they caught between the compliance and anti-sanction and sanction formalities. They, for example, want to retain access to Western financial institution. And further, if the client is considering succession planning, they may be thinking that what be happening to the assets of the business, and if they would be passing to some members of the family who are not Russian citizens, for example, only holding citizenship of the other countries, unfriendly countries, that would be unfriendly persons. And the structure under control of unfriendly person would be an unfriendly structure with all these restrictions once again being applicable. So, say if the son of the client would be holding, say, a US citizenship only, not holding Russian citizenship, that would be a problem once again. So, next slide, please. Another exercise we advised the client on was one could say less complex, but not necessarily. The client from a European state happened to own real estate directly in their name in Russia, and there was an intent to sell it, obviously. That direct sale to a Russian person would have required a consent of government commission, and the money would have been credited to IPC account, effectively being locked in Russian economy forever, or at least until these restrictions will be lifted off. And that was something the client, of course, was not able to agree with. So a friendly non-resident was located. There was a person from one of the CIS countries who was willing to acquire the real estate. Well, I wouldn't say that was a nominee, but we don't really know whether this person sold this asset next to somebody else. I can only say that this person, being as a seller, would not be meeting these restrictions. The CIS person, the first buyer, would be able to resell this real estate to anyone else, save one friendly person. Say, for example, if the actual buyer was a Russian citizen, that Russian citizen could have bought from the CIS person, and this transaction could have been completed in two steps. Well, of course, Russian law doesn't recognize trust, and the issue of how to structure the relationship between these CIS person and the true Russian buyer would be quite a challenging exercise. But fortunately for us, we were representing the seller, the EU person, not the but this hypothetical Russian buyer and his friendly CIS first buyer. So I can only speculate if there was a subsequent buyer and how they would have structured their relationship. But that could be a solution to a situation like that. Next slide, please. And following to the notion of succession planning and being intending to keep the lifestyle clients enjoyed before 2022. Many of our clients still have connection to European jurisdictions. They live there, they have property there, they have um, bank accounts there, financial institutions continue to serve them, but they see the compliance pressure in the form of asking questions where they have connection to Russia, where they have business in Russia, where they have income from Russian businesses, for example. They also have the same pressure from Russian state when the fact that the business owner is living outside of Russia, holding a residence permit, having bank accounts in financial institution could be seen as a sign of political unreliability, so to say. So they are seen as disloyal citizens of their motherland. Sometimes holding a residence permit in another country is has a legal implication as well. For example, we have legislation on investment in strategic industries where even a Russian citizen but holding a residence permit in another state is qualified as a foreign investor and has to obtain consent of acquiring shareholding in strategically important industries. But even if the client's businesses are not of strategic importance, well, the risks of business being seized on these or that grounds is still high currently, and they would want to distance their Russian assets and businesses from any foreign connection. Now, in this case, both these matters, these issues could be resolved by using Russian foundation, which is a legal concept similar to private foundations in most European countries. This is a legal entity which doesn't have any shareholders. The founder bestows the assets with the foundation, appoints the council, and approves the charter and the internal regulation, and then the foundation just continues to exist based on this regulation for the benefit of beneficiaries who, however, don't have any control. The control is vested with the council members. The council members could be appointed by the founder, by the paterfamilias, for example, being only Russian citizen. Family members, family lawyer, trusted persons, persons engaged as an independent directors, for example. These persons could form the council and be treated as UBOs for Russian legislation purposes as persons who have control. The founder and his family members could be beneficiaries as persons who are entitled to receive the monetary payment from the foundation. But they wouldn't have control. So that would be one way to ring fence Russian assets from the foreign from the founder who and his family members living outside of Russia, because we saw cases in practice when the business is structured in a more traditional way with the chain of shareholding leading to next generation of the founder's family who have lived and, for example, received education and obtained citizenship in other countries, which are now treated as unfriendly. These family members are seen as a target when there is a corporate conflict, for example, or even if the state believes that the business needs to be seized for the benefit of the state because it's too important for the economy. So this would be one way to separate the family members connected to other jurisdictions from their Russian assets and serve both of the needs I have described before. Next slide, please. So thank you so much for attending our webinar today. And if you have any questions, please use the chat function below or send us email using this address you may see on the screen now. And it was a pleasure. Thank you.
Thank you very much. I believe that we don't have right now any questions on the chat, so we will be pleased to answer your questions after receiving them on our email. So see you later. Thank you and goodbye.
Thank you.